In this video, I'll look at the main issues that planners face in the difficult area of justifying agricultural or rural workers' homes. How do the accommodation needs of agricultural or rural workers justify building new homes in entirely rural, open countryside locations where it would otherwise not be acceptable? I've lost count of the number of times I've been asked whether someone can build a new house on a field in the middle of nowhere. In many cases, the answer is no. The follow-up question is, why can that farmer have a house and I can't? So I thought it would be useful to cover some of the main issues planners face in justifying or approving agricultural or rural workers' dwellings. My plan is to look at some of the basic principles behind the case for agricultural workers' dwellings. I will consider the thorny issue of what size of house should be approved for a farm worker. It is worthwhile looking at the definition of a rural or agricultural worker. One piece of case law that often comes up and is relevant whenever I'm asked the question about the justification for a second dwelling, sometimes known as succession dwellings, on a farm is the Keene case law. Finally, and probably more controversially, I will look at the situations that might justify the removal of an agricultural worker occupancy condition, or ag tags, at some point following the approval of an agricultural worker's house in the countryside. So then, what is the big deal about resisting new houses throughout the open countryside? Well, if we were to build new houses in isolated, unrestricted, open countryside locations, we would not have open countryside for too much longer. Whether we're talking about national parks, areas of outstanding natural beauty, the green belt, or just simply the open countryside, there is a strong, reasonable, and entirely justifiable presumption against development. Essentially, a new house in an isolated open countryside location can only be approved where it is considered to be an exception to both national and local policies. It is therefore helpful to look at a typical local plan policy to see how a council might assess those exceptional needs. Harrogate Borough Council, now known as the much larger North Yorkshire Council, adopted its local plan relatively recently. The policy relating to rural workers' dwellings followed many of the key principles that had previously been laid down by the now defunct Planning Policy Statement 7. The areas I have underlined in this policy are probably the most relevant parts. This states that new isolated dwellings in the countryside will not be permitted unless it can be shown that there is an essential need for a rural worker to live permanently at or near their place of work within the countryside. The criteria listed under this policy state that there should be an existing functional need, that the need relates to a full-time worker, that the unit and rural employment activity should be financially sound, that the functional need could not be fulfilled by another existing dwelling on the unit or nearby, and that the house would otherwise be suitable for the occupation of the rural worker. The policy then goes on to state that the first 3 years following the grant of planning permission should be provided through a temporary dwelling. It is probably worth noting there are a number of variations or elements to consider that would impact on the interpretation of this particular council's policy. However, it is useful in setting out the key principles in considering the justification for a rural workers' dwelling. Annex A of Planning Policy Statement 7, or PPS 7, provided the main policy principles relevant to any planning application for agricultural or rural workers' dwellings. That has now been replaced by the National Planning Policy Framework, or MPPF, and the detail contained within PPS 7 is now mostly lost given the summarised nature of the MPPF. However, the functional and financial tests that underpin the principles set out by PPS 7 remain relevant and can be seen in the previously discussed local plan policy from Harrogate. In building a case for a new dwelling, it is important to show there is a full-time workers requirement to be on site. It's not sufficient to have a dozen pigs and claim that 2 or 3 times a year those pigs will have piglets, and the farmer needs to be on site at that time. A full-time equivalent rural worker will need to be justified, and that can often be more of a numbers game based on the number of animals, the acreage, or the general level of farm activity. I will discuss the more relevant case law on the subject of suitable or available dwellings at the farm later. However, those guiding principles from PPS 7 still mean, in looking at the case for a new dwelling, the local planning authority should consider whether there are buildings that could be converted to meet the needs of the unit, whether the farm could meet its requirements from a dwelling house close by in the next village, or even whether the original farmhouse could be extended to provide a family annex, and so meet those accommodation needs in a less intrusive way. Finally, the principles set out by PPS 7 also require that there should be a period of 3 years in which the agricultural or rural worker builds a financial case through their employment activities. In those 3 years, they would normally be expected to live in temporary accommodation. Again, this might not always apply, particularly when there is an existing business. A period of less than 3 years might then be more relevant. One of the biggest criticisms faced by planning authorities in their discussions with farmers is a reluctance to take account of the size of the farmer's family when assessing how big the new house should be. The key phrase here is that the new dwelling should be commensurate with the needs of the holding. Sadly, that principle rarely applies. All 4 of the houses on this page are agricultural workers' dwellings and are restricted with conditions that state the occupiers should be solely, mainly, or last employed in agriculture. That's the standard occupancy condition. One of the key principles behind justifying new isolated dwellings is that they should have the minimum possible impact upon the open countryside. Probably fair to say that 3 of the 4 dwellings here failed dismally on that score. As 5 or 6 or more bedroom houses, the rural workers that live here are clearly doing quite well. In truth, it actually becomes quite questionable whether the occupiers of those 3 homes are genuinely rural workers. And indeed, is there a reasonable case for a new isolated dwelling? So what then is a rural worker? Well, the 2 chaps on this page would probably certainly seem to fit the bill. We should, however, refer to the 1990 Town and Country Planning Act for a definition of agriculture. It includes horticulture, fruit growing, seed growing, dairy farming, the breeding and keeping of livestock, the use of land as grazing land, meadowland, osier land, apparently a crop grown in marshy land, market conditions, and nursery grounds. Crucially, those uses or occupations should also be forming the basis of a trade or business, rather than simply be a hobby. It is quite a common scenario for the children of farmers to take over the operation of the farm as the parents reach a certain age. The issue of succession dwellings therefore becomes relevant. In other words, how to accommodate the needs of the younger family when there is an existing farm workers' dwelling on site, and that original dwelling is serving the needs of the father and mother. The flow diagram on the right-hand side of this slide shows a typical thought process in assessing the needs of the farm business. Starting from the position, can an identified requirement for an on-site dwelling for a succession farm worker or rural worker be met by an existing house on the farmstead? If no, can it be met by reorganization of labor on the farm? If no, is it possible through an extension of the existing house? How about subdivision of the existing house? Alternatively, the conversion of existing traditional buildings? If the answer is no to all of those, it is necessary to look at a new dwelling. To do that, the business must demonstrate a functional need to be in sight and sound of the farm operations for a full-time rural worker. If it cannot, an application will fail. If it can, there's a need to demonstrate financial viability. And if it's not possible to demonstrate financial viability at that particular time, then a temporary caravan or chalet will be required for the 3-year period. If it is possible to demonstrate financial viability, then submit a planning application. At the start of that flow diagram is the question of whether the needs for a succession farm worker could be met by an existing house on the farmstead. Now, the case of Keene versus the Secretary of State and Aylesbury District Council is most relevant here. In that instance, the council refused planning permission on the grounds that the original farmer's house was both suitable for the succession farm worker and available. The appellant, Mr. Keene, argued that while the farmhouse might have been suitable given its location on the farm, it was not available. And indeed, it was unreasonable to ask the appellant's parents to move out. The underlined sentence is the key. This states the court held that it was unreasonable to expect the appellant's parents should vacate the existing farmhouse to make it available for an active agricultural worker. And that position has been upheld by other High Court judgments since that time. In other words, where the original farmer is retiring and has no plans to vacate the farmhouse, there is no requirement to provide justification for a second dwelling on the farm. Instead, the farmer's son or daughter should only provide justification for a single dwelling to serve the accommodation needs of the farm business. Now to the thorny subject of the removal of agricultural occupancy conditions. First question being, why do it? Now, as a general principle, the value of a house with an agricultural worker's condition attached to it is worth anything from 25 to 33% less than the market value without the occupancy condition. As either an asset value to the farm business or simply for the purposes of selling the farmhouse to realize capital, there is quite clearly an economic justification to remove the occupancy restriction. So how do we do this? The most common way in which to look at the removal of an occupancy condition is to see whether it is still relevant and required, either to the farm or the wider farming community. That would normally involve the marketing of the house for a period of around 12 months. The marketing exercise will clearly state that the dwelling has an occupancy restriction. And the purposes of that marketing exercise is to see whether there is a requirement for that house to remain within the farming community. One of the reasons your planning authority will look to restrict the size of a new rural workers' dwelling is that if it is excessively large, its value on the market, even with an occupancy condition, would take it out of the reach of a typical rural worker. Inevitably, a 5 or 6 bedroom mansion with an occupancy condition might still be valued at £1 million or more. And there are obviously few genuine rural workers who might be able to afford that. The second way in which to remove an occupancy condition is to show that the people who've been living in the dwelling restricted through the occupancy condition have not been complying with that condition for a period of 10 years. I should add, there are varying pieces of case law that might be relevant here. However, the 10-year period is probably the most relevant. In the event of being able to prove a 10-year breach, the owner would apply for a certificate of lawfulness. And while the condition would remain in place, the house can be sold to a person who does not comply with the condition, so long as that breach continues. A further potential justification for the removal of the condition is to argue that there was no real case for a dwelling in the first place. In other words, the occupancy condition was not correctly imposed, and indeed, the original house should not have been approved. It has to be said this is one of the weaker arguments to use, but it is still possible to base a case for removal on this premise. Finally, a case I dealt with at a local planning authority in the Tees Valley. The house edged red was first approved at some time in the 1970s, when at that time it was in an isolated location. This had an occupancy condition imposed at the time of its original planning permission. However, later housing development then enveloped the property, as you see. And it no longer sat in an isolated position. As such, I applied for the removal of the condition, and I'm happy to say that condition is no longer in place. The justification being that if an application for a new house were to be applied for today on that same piece of land, it would have been approved without the occupancy restriction. It is rarely the case that I'm able to cover all of the issues relevant to a subject within a few minutes on a video. I referred earlier to the policy within the former Harrogate Borough Council's local plan. They also have a useful supplementary planning document online that was adopted in 2021. Many councils have useful guidance, though the principally rural-based Exmoor National Park Authority also have helpful guidance about rural workers and succession farm dwellings. And of course, finally, if you can find a copy of PPS 7 Annex A online, it's a very useful document and sets out those key principles that I've outlined earlier in this presentation. If you are a rural worker looking for advice, do please search out an experienced town planner or chartered surveyor and take advice before incurring excessive costs. There is often a case for genuine rural workers or farmers to secure permission for new dwellings. However, there are far more attempts made by individuals with no genuine justification, and so planning authorities will usually start from a position of suspicion. And it is important to set out a strong, robust case, if indeed there is one. I hope you found this interesting. Feel free to leave comments, though you will appreciate I will not attempt to provide you with advice on your own particular case in those comments on YouTube. Thank you.